Hello everyone, welcome to Management 413 Employment Law here at the UAB Ch School of Business. In this video we will be covering recruitment using Chapter 4 of our textbook. Here's the outline of what we'll be covering, all the elements of recruitment that might have legal implications. Stop and pause, make sure you understand that. Employers use various forms of recruitment, and we will be looking at how some of them can give rise to claims of illegal discrimination. Want ads and job announcements. The wording must be neutral. The days are long gone that a want ad from 1947, as you see down in the bottom, would be legal. You can't hire an employment agency and have them illegally discriminate without your being found responsible for that. The test of whether or not you are fulfilling your obligations, at least for disparate impact discrimination, avoiding disparate impact discrimination, would be to make sure that you are aware of the relevant labor market when you are recruiting. What is the protected class composition of people who are qualified for the type of work in question and that reside in the area where you will be recruiting? Nepotism can be a very risky method of recruiting. It refers to favoring your relatives and friends. It's not necessarily a violation of Title VII, but it can lead to a disparate impact if you don't have a diverse pool of employees to begin with, and they are recruiting their friends and family who are not diverse. And it is why many employers, including UAB, for example, have a requirement for external searching for each and every position that becomes available. Let's look now at the recruitment of foreign nationals, people who are not citizens of the United States. That is a legally intensive area because the government has to step in and give permission to people who are foreign nationals to come in and work for you in the United States. There are several classifications of visas, which is the permission to come and work in the United States. An H-1B visa is a type of visa that is available only in specialty occupations. Take a look at the NBC Learn video in the learning module about what Silicon Valley faces as far as fulfilling the high technology needs there and their need to recruit foreign nationals. They would be what you'd call an H-1B dependent employer. B stands for business. An H-2 visa is also available. These are for foreign nationals who come for temporary or seasonal work. This is a picture of Melania Trump, who raised some questions in the summer of 2016 as to exactly what was the type of visa she was here on. If she were really here on an H-1B visa, she would not have had to go back and forth to Slovenia, where she was from. That is only necessary if you have what's called a B visa, a tourist visa. An L visa is also a type of permission to come in and work in the United States. This is for multinational firms that need to move their employees around from time to time on a temporary basis. Let's move down now to the application process generally. Here are some steps for how the process should look, what the application should look like. You should have a period of time during which applications will be accepted, and then you should close that and use a consistent set of rules for that so that no one can say, well, you kept that job open for a day and you kept this other job open for 3 weeks because you were trying to get a certain person hired. There are some record keeping requirements, including the requirement that you keep the protected class characteristics of your applicants on file. That has raised some questions about who really are our applicants. The government's definition of an applicant is very broad and would include someone who merely expresses an interest in a job over the internet. Things can go wrong in the application process. Look what happened to Target in their application process when they were trying to fulfill their record keeping requirement and guess as to the race of their applicants based on names or accents. During the application process, it is illegal to directly inquire about someone's protected age characteristics. For example, asking whether someone is a U.S. citizen. It is against the law to discriminate against someone on the basis of citizenship. It is also against the law to indirectly try to get at that. For example, by asking for the date of graduation from high school, because that would usually be at age 18. Here are some bad ideas for pre-employment inquiries. Take a look at these, stop and pause. Do you have any health problems that would affect your employment? That would not be a good question to ask. As we'll see in a second, the better way to handle that is decide whether the person is qualified, but make a conditional offer of employment conditioned on some sort of medical exam. Here's a simulation that a pair of you will get. A 55-year-old woman whose application asked her to indicate, quote, the year you started working professionally. Was that illegal or no? Employers should also avoid questions that are not going to be uniformly applied, such as, for example, asking women about who's taking care of their young children, but not asking men about that. And employers should avoid asking questions that are going to have a high probability of an adverse impact, such as asking about arrests. The statistical truth is that African Americans are more likely to have an arrest record than Caucasians. So if you ask about arrest records, you are going to have an adverse impact on African Americans. It is, as I mentioned a second ago, illegal to ask for a medical exam prior to making an offer of employment, but you can make a conditional offer of employment conditioned on getting a medical exam. Following the conditional offer, the employer can make the medical inquiry, can't make genetic tests, that is never allowed, and the information that you learn should be used strictly to determine whether the person is indeed qualified or not. You may not use the information learned from a medical exam to discriminate against a qualified person. Take a look at this case example from Huntsville, Alabama, where an applicant suffered from epilepsy, took drugs to control that. He was not disabled. He applied for a job at a company in Huntsville and was required to take a drug test that detected the drugs for his epilepsy. And the employer, after that drug test, revoked his offer of employment. He was not allowed to work there. And the court held that a reasonable jury could decide that the reason the company decided not to hire the applicant was because of the drug test. Social media can be a risky way to conduct your recruiting. If you think that you can go on to Facebook and look at someone's profile and posting activity, if it's public, of course, that would probably be a bad idea. At least 9 states say that that is expressly illegal. Even where not expressly illegal, it might lead to you becoming aware of people's being in particular protected classes, and that would put you on notice in case you took some adverse action, and the uh, employee or the applicant could prove that you were aware that they were in a protected class because of your looking at Facebook. So it's probably not worth the risks that would come from using social media in the recruiting process. Employers should be careful in the statements and information that they convey to applicants, because those statements can be construed as promises, and promises can turn into contracts, or can turn into arguments of fraud or negligent misrepresentation. Here are the elements of a fraud claim that someone might make based on an employer's promises during the recruiting process. Stop and pause. Make sure you understand what those elements are. Negligent misrepresentation. This would be a situation where an employer made statements and just wasn't careful about it, as opposed to fraud, where there was some intent to deceive. Negligent misrepresentation does not require proof of intent, just that the employer should have known about the falsity of the statements that it was making. Look at the case brought against Amazon a few years ago, where the court held that a jury could reasonably find that Amazon had fraudulently induced him to accept a position with promises of stock options. Statements by employers can also give rise to claims that there is an oral contract that has been breached. We'll have a simulation on that. Here is a real case. A foreign physician in Pennsylvania brought over from outside the United States to work on a visa that had a certain number of years on it, as all H-1 visas have. He thought that he had a promise from that American employer to stay on the job for the length of the visa. He was terminated before the visa had expired, and he complained to the employer, and then eventually sued the employer. And the simulation will ask you to give us what the result of that is. Employees must also watch what they say. What they say to their employer during the recruiting process can have legal ramifications. For example, if they have falsified their resumes or their applications, or omitted material things, that could give the employer grounds for revoking an application or even for termination. Look at the textbook page 143 for an example of that. That's it for this set of slides. In our next set of slides, we'll be looking at another aspect of the recruiting process, that is background checks, references, and verifying employment eligibility.